This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Dovia. Tonight we're taking your calls and questions about workers' compensation, and we're taking it from both directions, whether you're an employee and you worry about what would happen if you got hurt on the job, or you're the employer and you have to pay into this system. We're going to talk about workers' compensation, how it works, what are the rules for filing a claim, what if your claim gets denied, and does the system favor one side or the other? We've got all kinds of information for you. The 31 Law Call number 256-536-0077. We will also have some of your email questions. You can send an email question on any legal topic any day of the week. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we pull out some of your email questions, and we will have some of those tonight. Getting us started tonight, Will Lee is here from Timberlake & Lee. Good to have you here.
Right, Sharon, workers' comp, excited?
Workers' comp. Before we get to some of those questions and introduce our guests, we've got some video for you. You make the law call tonight. We've got some video from YouTube. This is taken at a foundry kind of situation, and a worker in this this little vehicle is about to put some wet metal into the furnace. And we're going to talk about when an injury happens. So he's on the job. He's doing, I don't know if he's doing it on purpose. Is he aware of what's happening here? But something goes very wrong. When you get hurt on the job and he manages to back it away, we're not sure what the extent of his injuries are. He's hurt on the job. What will his employer do? What is workers' compensation there to help him with? Will, get us started talking about this a little bit.
Workers' comp is a love-hate relationship. The good side of workers' comp, I mean, this guy, as you said, it's probably against procedure to put wet metal in there.
Probably.
And he did. But the good part about workers' comp, it does not require to prove fault. If you make a mistake as an employee, it won't be held against you in compensation. So that's the good part. The significant bad part is you're very limited in what you can recover under the Workers' Compensation Act. And basically, it was designed back in the Industrial Revolution and all that. There's horrific injuries, but oftentimes they would find that you did something wrong or improper. And under contributory negligence, if you were found to be at fault, even slightly, you cannot recover. However, workers' comp took that out and is now no longer a requirement that you prove all the fault is on the employer. So if you make a mistake, you're still covered. Now the bad part is you're very limited in what you can recover. And the theory is to keep people, a lot of people paycheck to paycheck. It will pay you 2/3 of your average weekly wage while you're off work with a doctor's excuse. You're entitled to 3 things, Sharon. 1, all your medical bills paid for life for that particular injury. Okay. 2, if you suffer any type of impairment, then you can be compensated for that type of impairment. And basically it spits out, like let's say your arm is worth X amount of weeks. Then you will get $220, which is the max, $220 for X amount of weeks. However, if you lose an entire arm, it's all those weeks. If it's percentage, then the book or the code spits out a number, what your claim is worth. Okay. So it is not a very lucrative, far from it. It's only designed to keep you afloat, and it's a very antiquated system, especially in Alabama. And it is a love-hate relationship. You don't have to prove fault, but again, the benefits are so limited, and they hadn't been changed in over 30 years. So we fussed at our legislature, it hadn't been increased, and Alabama is sadly one of the last states to compensate its injured workers. And we've got a great guest. We're against Mr. Ryan Blake a lot. We like Ryan Blake. However, we're not crazy about his clients. We're always fussing. Ryan,
because he represents the employers,
right?
We're
going to go ahead and get it going. But I'm going to go ahead and start off. We're always fussing with Ryan's clients to try and approve doctors to get treatment. Ryan, I'm going to go ahead and, first off, thank you for coming up before I get on to you too bad.
Well, thanks for having me.
Yes, sir. But why is it so difficult for your clients to approve medical treatment for my injured, innocent clients where a doctor has recommended treatment?
Ryan, and his client would be the employer, right? He represents the employer, and you're representing maybe the person who's injured.
He represents the employer, but let's get down really, he represents the insurance company.
Okay.
But the employer is technically his client.
Okay.
So welcome, Ryan. So yeah, what you got on that?
Well, thanks. I mean, so most of the employers are self-insured, but they have a third-party administrator, which is kind of like an insurance company. And adjusters monitor the claims, and the adjuster's job is to determine if the medical treatment recommended by the doctor is related to the on-the-job accident and if it's reasonable and necessary. So maybe that's why sometimes there's some delay in approving medical treatment, but I think that most adjusters do the very best they can to keep up with the injured employees. And if not, then there are people like Will League and Michael Timberlake who will make sure that happens. And isn't that right, Will?
Well, a lot of our fussing is trying to get our clients. And what the frustrating part is, let's say client's hurt on the job. Let's say that guy on the forklift.
Yeah,
let's say
the
he needs
guy.
a surgery.
Okay.
He's burned up. They say we need a surgery. The doctor who sees him at the hospital recommends a surgery. It goes to workers' comp. Workers' comp oftentimes will have a doctor in some other state review those medical records. He doesn't need that surgery, and then they deny it. And so then we have to go file the case and get to the judge and try and have that surgery approved. Well, a lot of times time is of the essence.
Sure.
And you need that surgery,
Yeah.
and much less you're suffering and things like that. I agree, the adjusters, they're trying their best, but I just can't go along with, and I get it, their job is to save their client money, but our job is to try and get our guy, medical care for that injury, and they have a right to defend these things. But more often than not, we're fussing with Ryan's client about that approval. Now, Ryan, you have to go to a workers' compensation approved doctor, so we're already behind the 8 ball because they're all y'all's doctors anyway. I get it. But then tell us about the list of 4. We can request one time and get a panel. What does that mean? And do y'all own the panel doctors too?
Right, we own them. So if the worker is dissatisfied with the initial authorized treating physician, and if more treatment is required, then the worker can request a panel of 4 physicians, and the insurance adjuster or the company gets to pick the 4 doctors. They have to be 4 doctors of the same specialty as the original authorized treating physician, and actually the law says that you can request a panel of 4 surgeons too. So theoretically, an injured worker could get 2 panels, a panel of 4 doctors and a panel of 4 surgeons.
Okay, guys, we've got a caller waiting. Daryl is on the line with a question from Lexington, Tennessee. Hi, Daryl. Thanks for calling. What's your question tonight?
I
Yes.
was injured on the job,
Okay.
and I received a settlement, and they kept life, on my wrist,
Okay.
and then the company shut down. So what do I do then?
So,
Okay.
so they kept your wrist injury, they kept the medicals, what we call, they kept them open?
I think that's what he means.
Okay.
Yeah.
All right, so
Yeah.
you're entitled for treatment for that wrist for life, but you're right. If that company shuts down, they still have an insurance company. In Alabama, if you have 5 or more employees, you have to have workers' compensation insurance by law. And if that company shuts down, your insurance company that was still responsible for your medicals. If that insurance company goes out of business, there's a guarantee fund that comes in, a subsidiary insurance company that come in to transfer that, and take care of that particular insurance company's obligations under keeping medical bills open, and that's why they have to qualify under the laws of Alabama to write insurance. And so if they go out of business, there has to be some type of plan to take care of all of those claims that are still ongoing. Ryan, when you have an employer that goes out of business, do you still maintain that relationship with the insurance company, even though you've got ongoing medical claims open?
Well, most certainly. So the insurance companies such as Hartford or Sedgwick, the injured worker should have an insurance adjuster that the worker has been dealing with throughout the course of the claim. So the fact that the employer may go out of business doesn't mean that necessarily the adjuster is out of business. So what you would need to do would be to call your adjuster and ask for medical treatment, or in the alternative, maybe pursue settling the future medical benefits and get some money out of it and go find a doctor on your own.
Now, Daryl was calling from Tennessee. He may have been injured in Alabama. It may have been an Alabama company. But do all states have something like this? You don't practice in Tennessee, right? And nor do I.
There are similar systems out there.
Okay.
And what Ryan's talking about is, let's say you're having a lot of trouble getting your adjuster, or having, in this situation, Daryl's wrist, he's having trouble getting them to, which is not unusual. You call, you don't get a call back, and it's a big, it's a big hassle.
Yeah.
You need treatment. It's hard to get it approved. But what you can do is close medical bills, and there's a big push in the last decade for insurance companies to close these to go ahead and limit their liability. Sometimes that's advantageous to a client. if they hadn't had any problems with their wrist, or if they're having so much trouble that they would rather get a lump sum payment and they can attribute that money to future treatment and find a doctor on their own, and then they're not subject to the workers' compensation doctor, who oftentimes answers to the workers' comp insurance company. They try not to. Most doctors are straight up. They're trying to treat their clients. But oftentimes when the doctors have issues with is they recommend treatment and then the insurance company does not approve it. And it makes it a big issue to try and get that. So what you can do is close medicals, get that lump sum payment, and then use that for future treatment.
So you guys are talking, and you're talking friendly because things normally work out. How often do you go to trial against each other? What are trials like? What are cases like when you cannot agree?
Well, Ryan, we were in trial actually last year together, week-long trial over in Decatur, and Ryan's a nice guy, but he's a lion in the courtroom, and we're always,
you got to do your job, right?
Yeah, he's ferocious, and we're fussing and whatnot, but he's one of the lawyers that we can shake hands and we can agree to disagree on some issues, but you know, it's not like a wrestling match.
What are most cases like? Ryan, how often are you actually taking a case all the way to trial?
Very rare. I would say over 95% of workers' compensation cases are going to settle either between the lawyers after talking to our clients or at mediation. Maybe 5% go to trial. The trials are non-jury. And that's probably the reason we're able to settle, because as lawyers we can pretty well predict what these judges are going to do with our cases. And so there's risk on both sides where maybe Will would hit my client with a big verdict, or on the other hand, maybe Will wouldn't get a bunch of money because I was a really good lawyer that day. But that's why we have the civil justice system, isn't that right?
That's right. You know, and he's always a good lawyer. And so what we're usually dealing with in workers' comp is what happened. Was my client, you know, even if my client was at fault, we can still recover as long as he or she is not involved in horseplay, was on drugs, something to really take them out of the workers' compensation act. What we're usually dealing with is the facts of what happened. Was he involved in horseplay? What is his average weekly wage? What type of treatment did he or she get? And then was there a permanent injury or a permanent impairment? And then you take those together, submit those to the judge through doctor testimony, witness testimony, and then the judge comes up with, based on the workers' compensation code, how many weeks for that particular injury, and then it's a formula to determine what the value of that claim is. Oftentimes Ryan and I can agree based on the facts that we have from the doctor and the witnesses, but if we can't, then he's exactly right. We go to a judge and ask the judge to determine what exactly is compensable for that injury, what is the impairment rating. Oftentimes we'll have vocational experts come in to testify, because it's a big difference is if you're a doctor and you break your back. Yeah. But if you're a furniture mover and break your back, it's a significant difference of what you can do, what type of job you can do, and what you can be re-educated or retrained to do. And so all that comes into play. And remember, it's about keeping people working, keeping people in the system to where they're receiving, they're receiving a paycheck, they're paying taxes, and we want to try and rehabilitate them to get the best job they can, and it benefits everyone.
Let's take a quick break. We'll be right back answering more of your questions about workers' compensation. Call in 536-0077. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovian, with the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients, and the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning, and the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back. I'm Sharon Dovian. Tonight we're taking your calls and questions about workers' compensation and being hurt on the job. We've got with us Will League, who is with Timberlake and League, and we've also got sometimes his adversary in court. We've got Ryan Brake, who is from Florence and who represents employers who are caught in the middle of these kind of cases. And we've got callers waiting. Renee is on the line with a question from Madison. Hi, Renee. Thanks for waiting. What's your question tonight?
Hey, thank you.
Sure.
So I work for a very small company, and sometimes we use independent contractors to do, various consulting efforts for us. And I know that, you have to have a certain number of employees to be required to have workers' comp in the state of Alabama. So if it's like a 1 or 2 person operation and they don't have to have workers' comp on their own, if they get injured, like they're out at a project site or something on our behalf, they slip and fall and, get injured, do they file on our companies? I mean, how does that part work?
Good question.
Ryan,
All
what do you
right.
think?
Well, independent contractors are not necessarily covered under the primary employer's workers' compensation coverage. There's a 4-part test, or maybe it's a 5-part test under the law. It's called the reserved right of control test, and it would look to who provides supervision, how the independent contractors are paid, and those types of factors to determine whether or not the independent contractor is an employee or not. So you can't cloak an employee as an independent contractor and get out of paying coverage. But on the other hand, if it's a true independent contractor, then the primary employer would not be responsible for workers' compensation benefits for injured employees of the independent contractor.
So you might have different insurance for that, but then there's going to be a lot of different rules, right?
Well, where the rub is okay, again, 5 or more, you have to have workers' compensation insurance.
Okay.
Oftentimes we'll have employers say, you know what, I've only got 3 employees and I got 5 independent contractors. But again, just like Ryan said, there's a test to determine, do you control that employee? When, where, how to do that particular job.
Okay.
Then you're essentially that person or that entity's employer. However, if they are truly an independent contractor, they do the job when, if, how they particularly under contract or however, and if you don't maintain that level of control, they're not an employee, so they won't have to have workers' compensation insurance, and that keeps them below that 5 employee threshold. If there are less than 5 employees, oftentimes we look at what's called the Employer Liability Act, which you can be compensated outside of the workers' compensation realm, but again, you have to prove fault and negligence in some way. Okay. So it changes the rules a little bit, but if the caller, if they only had 2 employees and they're truly independent contractors, they are not covered under their workers' comp. I completely agree with Ryan. I guess I'm agreeing with Ryan tonight. So.
It's a first. Okay, we got this email question. This is from Robbie. Robbie wrote in, I spend a lot of time in the car calling on clients, and I was in a bad wreck on Friday. I'm sure my employer has workers' comp insurance. Does that mean that I'm covered and I don't need to file a regular insurance claim? Okay, does something like this, does it maybe fall under workers' comp?
It's 2 things really. It can be under workers' comp because if the caller said they're under the line and scope of their duties for their employment while driving. It can be workers' comp. It can also be a third-party tort claim. The difference is the level of compensation. As we talked earlier, workers' comp is a very poor body of law in the way of compensation. However, you don't have to prove fault. The tort claim, or a regular insurance claim, as the caller referenced, is a claim against the other driver, essentially the other driver's insurance carrier. Now, you could have 2 of those claims going on at the same time. Let's say workers' comp pays your medical bills and pays you time off. If you recover from the other driver's insurance carrier, you will have to pay what's called subrogation back to the workers' compensation carrier. So, let's say Ryan represents the workers' compensation carrier. He will write me a letter and say, hey, my client has paid $50,000 for a surgery, $20,000 for average weekly wage, lost wages. You owe us $70,000 when you resolve this case, Will. And he's watching me to make sure that I do the right thing. So if I file a claim against the defendant driver, Ryan, sometimes you'll either write me a letter or sometimes you can enter in that case. Is that right?
Right. Well, in the case that we spent a week trying last year over in Decatur is a case where, Will, your client was injured in an industrial accident, but the injury arguably was caused by a third party, and your firm, on behalf of that injured employee, sued the third party. And so after we paid workers' compensation benefits, then I was at that trial because if you won, you owed money.
That's right.
So, of course, we would pay a shared portion of the attorney's fee in the third-party case as well.
Mm-hmm.
Gotcha. Okay, so what if, does it matter, like in this, Robbie's talking about that he's calling while he's driving. I mean, are there some things that might get you out of workers' comp if you're not following some rules? Does it mess things up?
Well, it wouldn't get you out of workers' comp, but what it could argue is it could be a situation where you're on your phone, you caused or contributed to that wreck, and you would not be able to recover under Alabama law. Remember, contributory negligence in Alabama, it's a very harsh law, and we're still one of the only states that use that antiquated, repressive, ridiculous law that says you cannot recover. So
If what?
Let's
If
say
you
I'm driving down the road, drunk, steering with my feet with my head out the sunroof, and I'm going 100 miles an hour.
Okay.
And we're coming up to a four-way stop. And Sharon, you come up to the four-way stop, and there's 10 nuns on the side of the road, and they see your wheels almost come to a stop, but you don't really come to a complete stop.
Okay.
And you roll through that stop sign. You
And
roll
you hit
through
me.
it, I go 100 miles an hour through it, and I hit you. The law in Alabama says you cannot recover against me, the drunk, because you were partly at fault because you rolled
One
through that
little
stop
bit.
sign. So how fair
Okay.
is that?
That's
and
not
so
fair.
if that happens, then Ryan is our only avenue of recovery, and
Okay.
if you're in the
On the
line
job.
of scope of your duties.
Yeah. Okay. Interesting. Okay. Talk to us, Ryan, about some other things that might play into some of that other defenses.
Well, in terms of the email with the car accident, just because you're driving down the road doesn't mean you're on the job. And so, generally going and coming to work is not covered under workers' compensation. But, if you have a job that inherently requires driving, like an insurance agent or a person who moves around because of their work, then that would be in the course of your employment. But when I get up in the morning and have a cup of coffee and drive to the office, I'm not in the course of my employment until I'm at the office. If I get in my car and drive to Huntsville because I've got court, then that car accident will be in the course of my employment, and I should receive workers' comp if there's an injury.
Gotcha. What about, okay, so things like if the employee is drinking or is using marijuana or something like that, does that make a difference?
It needs to be, I mean, if you're drunk and you're standing in the yard and a wrecking ball falls on your head, your drunkenness didn't cause or contribute to that particular injury. But if your intoxication leads to that particular injury, or you fail a drug test, then you workers' comp could pull that coverage.
Okay.
Ryan,
Okay.
do they have to show, again, they was involved in horseplay, or just if you failed the drug test, where are you on that in terms of whether it'll kick them out of coverage?
Right. It's an affirmative defense for me if an employee is intoxicated and we deny coverage, but we've got to prove that the intoxication was the proximate cause of the accident and that the accident wasn't just an accident.
Gotcha.
So just because somebody steps in a hole and they're drunk doesn't mean that they stepped in the hole because they're drunk.
Gotcha. Okay, they're telling us to take a break.
Okay.
Okay, take a break. We'll be right back answering more of your questions about workers' comp. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Ryan Brake. He is with Carr Allison out of Florence. He does insurance defense, number 256-718-0832. Also check out carallison.com. Here's how to get in touch with Will League with Timberlake & League. They are personal injury attorneys, so that's everything from workers' comp to medical malpractice, nursing home negligence, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about that way. You can also see them tomorrow on WAAY 31 Midday News.
And Sharon Dovey at Family Law, Custody, Child Support, Alimony, 539-7337, SharonFamilyLaw.com.
Thank you. Thanks for all your calls and questions. Ryan, thank you for staying up with us and coming over from Florence.